Cameron Soren Law, and today we're going to be talking Chiafalo versus Washington. Now, this entire case stems from several electors in the Electoral College, who ultimately decided to vote for someone else other than who carried the state's popular vote. In this instance, Washington and Colorado. Essentially, what they were trying to do in the 2016 election was write in a different name that would hopefully prompt other electors to follow suit and change their mind and deprive Trump of the needed number of electoral votes to become president. Perhaps a bit dubious strategy, but this is ultimately what they did. Now, each state had what's so-called faithless elector laws or statutes that allowed them to essentially remove and punish in the form of a fine these electors from voting for someone else other than who carried the popular vote. These individuals then challenged these laws as being unconstitutional. So each case came before the United States Supreme Court. Oral argument was heard separate on each, so it's a total of 2 hours of oral argument on this particular issue. And after oral argument, there were a lot of individuals who were very concerned as to the possible outcome of this case. It's like, maybe this is a really close case as far as that goes. Well, as it turns out, we get a 9-0 decision, which is relatively rare on constitutional issues. So, Justice Elena Kagan, writing for the majority, starts going through the history of how we sort of elect our president and throws in nice pop culture references like Veep and Hamilton and things like that. And notes that we've got a total of about 32 states plus the District of Columbia who all have these faithless elector laws that require each elector to pledge that they are going to cast their ballots in favor of whoever carries the popular vote in their respective states. And 15 of those states have shall we say, teeth to those laws, which allow them to essentially remove the elector, faithless elector, and also potentially issue a fine, like in the instance of Washington. Now, Kagan then moves to the actual constitutional provision regarding the electors, and notes that it's pretty bare bones. It provides that the states will appoint electors, that the electors will meet, that they'll cast ballots for the president, and that those ballots will go to Washington. That's about it. So these sparse instructions don't really take a position on how independent or faithful these electors ultimately are supposed to be to their respective states. But she notes there's nothing in the Constitution that expressly forbids the states from having the electors cast their votes as they direct. So Kagan turns then and goes, well, we don't have much in the way of constitutional text telling us one way or the other, even though it doesn't expressly forbid the practice. So we're going to turn to historical practice. And as she notes, historically, states have definitely wanted their respective electors to follow exactly who they want. This person wins the popular vote in our state, you go vote for that person. And the number of so-called faithless electors are actually a bit of an anomaly, and she backs this up with statistics. She notes that over 23,000 electoral votes have been cast in U.S. history, and only 180 of those have been faithless votes. And of that 180, a little over a third essentially comes out of one election back in 1872, where the Democratic Party nominee dies shortly after Election Day. So that's certainly an instance in which you probably should not blame the electors from potentially wanting to cast their ballot for someone else, maybe someone alive. So, and if you put those faithless votes from that particular election aside, you're talking about less than 0.5% in all of U.S. history. So given all of that historical information, plus the Constitution's text doesn't expressly forbid the practice, she concludes, hey, states can have these laws. Then you get a concurrence by Thomas, joined by Neil Gorsuch. And essentially, Thomas is very, very consistent and says, hey, Constitution doesn't say anything one way or the other onto this particular issue. And if the Constitution does not affirmatively grant the federal government power or take it away from the states, well, the Constitution has nothing to say about the matter, and that's it. Standard common stuff. Hey, if it doesn't address it, we shouldn't be ruling on it. So, the result of this ruling is that the current system remains in place. There were a lot of concerns with potentially hotly contested election, particularly one that's going to involve a lot of absentee ballots, that you could get some electors doing some interesting things with their votes. But at least for the states that have these so-called faithless elector statutes on their books, that's not really going to be too much of a concern. As always, hope you found this informative and entertaining.